Hello, my name's Kate Redshaw and I'm a lawyer in the employment team at Burgess Salmon, and I'm joined today by one of our partners, Katie Russell.
Hi, Kate.
Hi. So, Katie, I think it's fair to say I'm not going to win any prizes for insight if I say the pandemic has changed the way we work, not only how people work, but also actually where they work. And of course, possibly somewhat unexpectedly, during the pandemic, many people moved abroad whilst continuing to work for their UK employers, either to be with family or to work from holiday homes and so on. And it seems actually that plenty of people are continuing to want to work in this way.
Yeah, so we saw a lot of that during the pandemic, as you say, where everybody was working remotely. But I guess what surprised me is that those requests are still coming in. So lots of businesses now have hybrid working policies and lots of people are working remotely. That's far more common now. But what we're seeing is that clients are having employees ask if they can relocate to overseas locations either permanently or sometimes on a temporary basis. So commonly you'll have an employee who might ask to tag some remote working on the end of an overseas holiday or something like that.
Okay, yeah, no, that's interesting, isn't it? And I guess in the current climate, what with the war for talent and so on, employers are wanting to accommodate these requests. But Killjoy lawyer Claxon here, whilst it's doable, there are a number of potential downsides for employers actually as well, aren't there, in terms of agreeing to these requests?
Yeah, so I mean, the technology's there to support overseas working, and there's been huge progress on that front, but there are some legal issues that can make it less straightforward and potentially very expensive for employers, and particularly where the employee wants to work abroad on a long-term basis.
Yeah, I mean, I guess that's right, because as well as benefiting from, various UK employment rights, the employee abroad may be protected by local laws there in the host country. And I guess both the employee and potentially the UK employer may also be subject to various other local laws, whether that's, employment rights, tax, social security, immigration permissions, and so on.
Yeah, I mean it's a long list, and they're all points that the employer needs to consider. So, as I've said, to a degree, it will depend on how long the employee wants to be away from the UK, but it's important to look at all of these points before agreeing to make the move. So if you start with employment rights, so as we know, if an employee works and lives in the UK, then they'll be protected under two sources. So the first is the employment contract, and the second is any statutory employment laws. So in the UK, things like national minimum wage or working time. So if you look at the employment contract, normally the employee will have an employment contract in place that's governed either by English or Scots law. But if the employee is going abroad on a long-term basis and it's clear that, for example, French law is going to apply, then it might be appropriate to move that employee onto a local French contract just to avoid any confusion as to which terms apply. And in relation to statutory employment laws, this is an area that can sometimes catch employers out. So it's really important to understand what the local laws are in the jurisdiction that the individual wants to relocate to, because they may not mirror what's in the UK and they could be far more generous. So one of the examples that we see a lot is in European jurisdictions where terminating an employee can be far more difficult and it can lead to substantial severance payments. So definitely one to watch out for.
Okay, sound advice there. And what about tax and social security status?
Yeah, so it gets a little bit more complicated here, and I am not a tax lawyer, so I'd always advise that you take specific tax advice from the local jurisdiction. But broadly speaking, if the employee is relocating permanently or on a longer term basis, then it's likely that income tax would have to be deducted in the overseas country, so where they're actually going to be living. If they're only going on a temporary basis, then normally the UK employer can continue to operate UK payroll with the UK PAYE tax code. So that's more straightforward in normal circumstances. Another point to mention is corporation tax. So if the UK employer doesn't have a presence in the country where the employee wants to relocate to, then it's important to just assess and check whether or not they might be setting up a permanent establishment for corporation tax purposes in that jurisdiction. And that will depend on what the employee is doing when they're there.
Okay, I see. And what about social security? I think we touched on that earlier. What's the position there?
Yeah, so again, it can be relatively complicated. So again, specific advice is going to be helpful, but it will depend on which country the employee is going to and whether the UK has arrangements in place with that country. So if the employee is going to an EU or an EFTA country, then the employer might be able to apply for an HMRC certificate to exempt them from the obligation to pay social security contributions in the overseas country. But it's one to double check. And also a point of warning is that applications for the HMRC certificate can take a number of weeks to process.
Okay, crumbs, quite a lot of due diligence to do there, Katie, and the employee hasn't even gone anywhere yet. And we haven't talked about immigration permissions. So what's the position there?
Yeah, so what we tend to find is that the employee will often be a national of the country that they want to relocate to or want to spend their time in. But if not, then immigration permissions are likely to be required, even if they're only working there for a short period of time. So again, the employer will want to investigate what permissions are required and if there are any visa permissions that need to be put in place, not only for the employee, but also if their family is going to be moving out there on a permanent basis, then that's something else to think about as well.
Yeah, no, good point. And would employers, it's the employees who wants to move, I guess, would the employer be expected to help with those visa applications?
Yeah, I mean, normally it's a matter for the individual employee to progress if they're the one that's making the request to relocate. But often it will be in the employer's interest to have visibility of the process, particularly if they're going to be asked to provide information about what the employee is going to be doing there or otherwise support them with the application.
Yeah, no, I can see that. So as we said, quite a lot for employers to think about before the employee is actually gone and before signing off any requests.
Yeah, and I suppose one additional point to think about is if they're in a regulated sector, then again, that's something else to think about in terms of are there any regulatory issues or regulatory requirements that need to be thought about before they can move out of the UK.
Yeah, no, that's a really good point. So we've focused so far on what I would call sort of external obligations and liabilities. But Katie, what do employers need to think about, from their own perspective? So, for example, the impact on the contract of employment, protection of confidential information, data protection, health and safety. I mean, these are all issues that I guess a lot of employers will already have been thinking about, given hybrid working policies, because they all come into play there, really, whenever the employee is working away from the office. Now, we don't have time today to cover all of those, but is there anything from that list that you would particularly like to flag in relation to employees who are going to work from overseas?
Yeah, I mean, I think the employment contract's probably the most obvious place to start. So if it's going to be a permanent move, then as we've said, it might be sensible to replace the existing contract with a local contract. If it's only going to be on a short-term basis or periodically, then there might be some amendments that you would want to make to the employment contract to reflect the new working arrangements and also to include some protection for the employer. So you might want to specify in the contract itself the maximum number of weeks the employee can spend abroad. And you probably want to include reserve the right for the employee to return to the UK if that becomes, if there's a business critical issue or if it's in the best interest of the company for them to come back to the UK. And you would also want to have a term in there that relates to any immigration permissions so that if they lose the right to legally work where they're based, then you would want to, them to notify you, and that may be a requirement also for them to return immediately to the UK. One of the things that we see come up a lot is expenses, which can be a bit of a difficult issue sometimes. So if you are going to require the employee to come back to the UK for certain points in the year for team meetings or on a periodic basis, then you would have to think about, it's good to think at the outset about who's going to pay for those trips. And if there are additional urgent trips, again, who's going to meet the cost of those? And a related point, I guess, is in relation to company equipment. So if you've provided the employee with any laptops, phones, and other office equipment, then when the arrangement comes to the end, who's going to pay for those to be returned? And I think you mentioned confidential information. Again, you will probably already have in your employment contract provisions in relation to confidential information, but I think it's important to think about the setup that the employee will have from a practical perspective, to think about whether they will have any confidential papers, and if so, how will they be stored, how will they be disposed of, things like that. I mean, I could go on and on and on, but really it's important just to look at your employment contract and any of your key policies and just have a sense check to see whether they'll work in practice when the employee's working abroad.
Yeah, no, there's a lot to think about there, Katie. I mean, I guess one option might be to put everything in a policy. So, you know, how you'll deal with employee requests to work from abroad, and the implications and the consequences. And I suppose you could expand on some of those things that you flagged there, you know, in that policy, couldn't you, outside of the contract?
Yeah, certainly some employers are doing that when they receive multiple requests. So they're developing more of a consistent approach as to what they expect, and then it's helpful to have a policy in place for consistency.
Yeah. And I think one thing we ought to do actually before we draw this conversation to a close is just talk about data protection, because of course if the employee's role involves processing personal data in the host country, then you're going to get into the potentially knotty minefield of transferring data abroad, which has quite a lot of GDPR compliant provisions for employers to be aware of.
Yeah, that's right. And it will depend on where the employee's moving to. So transfer of data between the UK and an EU country should be relatively straightforward, because the UK has been granted adequate status. So personal data can freely flow between the UK and the EU, although you would still have to have some safeguards in place in relation to that data. But if the employee is moving from the UK to a country that doesn't have adequate status, then transferring personal data can become a lot more complicated. And again, you need to look at potentially taking specific advice and putting safeguards in place there.
Yeah, and it's probably actually also worth looking at the Information Commissioner's website. I think there's quite a lot of information there about transferring data abroad. So goodness me, a lot for employers to think about there.
Yeah, absolutely. And we haven't been able to cover everything today. So this is just really the highlights, as it were. So, but I mean, we are seeing clients who are making this work, and it certainly is possible. And as you've said, I think with the war on talent at the moment, it's something that employers are looking at more and more. So it is something that can work, particularly where the periods are relatively short. So a lot of the issues that we've talked about today arise more so when there's a permanent move, but it's really just for employers to be aware of the potential implications before they say yes.
Yeah, no, absolutely. That's very wise. Thank you, Katie. Thank you so much. There's some really interesting practical guidance there. And as you say, you know, we are knowing employers who are making this work. It's just, I think it's about careful planning, isn't it? And knowing what your parameters are and making sure that you've thought through the implications of what might be involved before you agree to the request, so that you're going in, I guess, effectively with your eyes open. I'm going to draw our conversation to a close. Thank you, Katie, again, very much for your wisdom there. If you've got any specific queries on this issue, or if you'd like to know more about how Burgess Salmon could help with your wider employment requirements, there are contact details coming up at the end of this video, or alternatively, there's everything you need to know about contacting us on the Burgess Salmon website. Thank you very much for watching.